Amaewhule, who had given an interlocutory injunction, or is it an order? And we'll try to understand how it affects this judgment given by Justice Basam, right? And we will talk about all of this and talk for development. Joining me on the show, it's been a while he's been on the show, is a professor of law, Rivers State University, and a very good guest on our show, I should add. I'm talking about Professor Ritchard Wokocha. Prof, it's good to have you on the show.
Good day, Kalada, and good evening, Nigerians.
All right.
Good to have you.
Okay, so can you help us? Imagine we were your students in a law class. Can you break down this judicial pronouncement by Justice Basam for us so we can understand? Because he has, newspapers, even my colleague, the reporter, is reporting that he has confirmed that the 27 lawmakers are still lawmakers and members of the PDP. So let's get your thoughts, please.
Well, first, let me begin by warning that nobody has been privileged to see the text of the judgment of the court, which we usually get to see when certified through copies are publicized. However, what has been reported as the judgment of the court indicates that some gentlemen led by one Hyacinth Amadi approached the Degema High Court and urged the court to grant them some prayers, including the fact that the 27 lawmakers, former lawmakers, are no longer members of the House of Assembly, and the court refused the prayers. The report said the court held that it lacked jurisdiction to hear the matter, because it believed that the gentleman who came before it lacked locus standi to bring the matter. Locus standi is the right or call it to bring a matter. It's usually deals with whether you have enough interest to support what you are bringing, whether it concerns you, to use a local language, local everyday expression, whether it concerns you, whether you have any direct interest in what you are talking about. And the court was of the opinion that the gentleman who brought the matters did not have such recognizable interest to warrant a court hearing what they have to say or dealing with the matter they want to deal with. That is the judgment of the court. But in the media, we have references to the fact that the court made reference to the fact that they did not bring sufficient evidence before it to show that the gentlemen were no longer members of the PDP, which they alleged that they had left, which the claimants who came before it alleged that they had decamped from. So the judgment of the court in a nutshell is, I have no power to hear this matter because there is no proper claimant before me. There is no proper party raising the question for me to answer. Therefore, I have no power to hear it. And the court dismissed the case.
So if the court, now going by, like you said, nobody has seen the true certified copy of that judgment, but the newspapers have carried it. Nigeria Info's reporters carried it as well. And what we are getting, like you mentioned not too long ago, is that there is no enough evidence. There is not enough evidence to prove that the lawmakers defected from the PDP. And of course, before now, we got to hear, Honorable Imo Gochire. We got to hear Honorable Imo Gochire come out to say that the PDP is looking at using the back door to bring the lawmakers back to the party. if the court does not have, the jurisdiction to hear the suit, then can it make a pronouncement like, reported by newspapers?
Certainly not. You have to hear the suit. You have to assume jurisdiction and hear the suit before you can make pronouncements on issues. So once you reach the decision that, I have no jurisdiction, I have no power, I have no competence to hear this suit because I do not have a proper party before me, it ends there. You cannot make any order. I want to think that what you're seeing thrown around on social media space and possibly some print media who have not seen the judgment too, is a misunderstanding of how the law works. Somebody comes to the court, I want this, the court said, no, I can't give you, you are not a proper person to ask for it. The court cannot be said to have made any orders.
Right.
However, let me point out that in law, in every judgment, there are two parts to a judgment.
Okay.
There is what we call the ratio decidendi, which is the judgment of the court with respect to the facts brought before it. The main judgment, what the court said concerning the issue brought before it. And then there is what we call obiter dictum. An obiter dictum is a statement made by the court when the court is making analysis to arrive at its main judgment. Those statements it will make, including analysis and instances it may give, are what we refer to as obiter dictum. They are not the judgment of the court. The judgment of the court is what the court's response is to the issue it was asked to make declaration on.
Okay.
So the court could have, and definitely likely did say, I have nothing showing me. Despite the fact that you are not proper persons to come asking for this prayer. I'm not also seeing anything showing that the men you're talking about have left the party they have left. So these are all reasons the court considered in reaching its judgment, which is there are no proper parties before me. I have no power to hear this case because there are no proper legally recognizable persons presenting the case for me to hear.
All right.
That is the judgment of the court. No other order could have been made.
Okay.
In any manner.
Now let's look at local standing. Now we have the Rivers elders, a group of elders under the ages of that, tied to Rivers elders, who are also in court. I think now it's at the Court of Appeal, if I remember correctly.
Yes.
And then we have the civil society organizations in Rivers State also asking the court to interpret, that section of the Constitution as to whether the defection was done right or not.
Hello, Kalado.
Can you hear me now?
Hello, Kalado.
Oh my, network is crazy. Can you hear me, Prof? Okay.
Can you hear me, Kalado?
I can hear you loud and clear. I wonder if you can hear me.
Okay, I can hear you now. I wasn't hearing you before now.
Okay.
You were saying something about our having elders who went to court.
And then Rivers Civil Society Organization also in court asking for the interpretation of that section of the Constitution about defection and all of that.
Yes.
Now, talking about local standing, talking about people who are, people of interest in the matter or related to the matter, how will this affect other cases? Would it also affect that case of, the CSO or the elders? I wonder. What's your interpretation?
First, the court before whom that matter is, if the other parties raise the fact that the parties who have come lack local standing, the court will have to look at the facts to determine that. I personally hold the view that those issues can hardly be dismissed on grounds of local standing. And my reason is that every such litigant is, one, a taxpayer, two, a part of the electorate, a voter, who voted. And so long as they prove that they are registered voters who voted in the election or who are registered voters in any case and therefore belong to a constituency, that is sufficient ground to sustain the suit, because it means they voted for a candidate. It means their position, their representation is an issue, and they are no longer represented in the House and all that. So that would be sufficient ground for a citizen to challenge a matter like that or to bring up a matter like that. However, every court considers what is before it and reaches a position. But concerning other existing cases, this case has no effect whatsoever on those cases. Because, as I said, what the court did is, sorry, I can't hear this case. I have no power to hear it. In my opinion, I do not have proper persons asking me to hear it. Therefore, I dismiss it because I have no power to hear it.
Could it
it does not affect any other case or any other parties, proper parties that are before a court of competent jurisdiction. Now, hearing an existing suit or persons who want to initiate a new one, it does not affect them at all.
Now, I was going to ask you, Prof, could it be that the reason why Justice Bassam said he does not have the jurisdiction to hear the case is because there is a process to which the seats of lawmakers be made vacant, and it has to be people who are lawmakers.
No. The court did not. The court could not have gone into that at all. That is hearing the matter and hearing the arguments. The court has, from the onset, said, I do not have power to hear this matter. I do not have proper persons asking me to hear it. Therefore, I lack the power. When the court says I lack jurisdiction, the court is saying I lack the power to hear this matter. Two things confer jurisdiction on a court. One is the parties who are coming before the court. They have to be proper parties recognizable to the law or recognized by the law as parties that can bring a matter. Second thing is the subject matter. If you bring a matter that the law says...
Prof, sorry, let me pause you. We have a commercial. When we come back, we talk some more.
All right. from Nigerian Info. And he tendered his resignation. Whether you accept or you don't accept, Canada has gone. It's not your business to determine whether he should go or he should not go. When it comes to those ones, it does not depend on what the receiver thinks. He has walked. I mean, he has taken off. So the question is, did they? And asking what I know now, or responding to what I know, or with respect to what I know, official resignation letters were read on the floor of the House.
Okay.
And approved. And they were declared as members of the House and the other party. Remember, the Speaker read out the 27 letters, including his own. And they declared that thenceforth they were now
members of the APC.
Lawmakers of the other party. Remember, a House is supposed to have lawmakers from as many parties as are voted into the House. So they did. And don't forget that there are pending suits in which they swore affidavits stating that they have resigned from their party.
Okay.
I think the suit before Justice Okorowo in Abuja, which is still pending, they took out that suit as members of the APC who have left the PDP, giving justifications for why they left the PDP and all of that. So I think it is somewhat, for me, childish to raise the question or consider the question whether they have resigned and whether PDP has removed their name from their register and whether APC has written their name in their own register. Those, for me, appear a bit childish considerations at this moment. Issues have gone beyond that. The gentlemen have taken their action, followed it up with a public display at the end of that sitting, and have filed suits in court stating on oath that they have. So on what ground are you raising the question whether or not they have, when they have stated that on oath before courts of competent jurisdiction? So I think those questions are neither here nor there. They are, for me, irrelevant considerations.
So this will in no way impact the Justice Wali Court's pronouncement.
No.
Interlocutory.
It will not have any effect on any matter, whether pending or about to be filed or that has been filed and determined. Because all the court did is, no, I won't do what you're asking me to do. You are not proper persons. I don't have the power to do it because you are not proper persons to bring such question before me. So it cannot impact or affect any other thing or any other matter. No. If the situation was that the gentleman went to court, asking court to declare that they are still members of political party A, that is PDP, or that they are still members of the assembly, and the court agreed with them, that's where you have to raise that question. But in this case, they were defendants who were sued by another person who was praying the court to do something for him, and the court said, I don't think you're the proper person. I lack the power to do what you're asking because I don't consider you a proper person to raise the issue. Therefore, I dismiss the matter. The court did not make any order. The court did not confirm or deny anything. Simply said, I don't have the power to hear this because I believe you are not proper persons. And it dismissed the matter. So there is nothing to have effect on any other matter. There is no judgment to have effect on any other matter. The court declined jurisdiction, declined participation, and struck dismissed the matter.
All right then. The Commissioner for Justice, Dagogo Iboroma, has also put out a statement, and he aligns with what you have said. He says that he is urging the public to disregard the news presently making rounds in social, print, and electronic media to the effect that Martin Amaewhule and 26 others have been declared as members of the People's Democratic Party and the Rivers State House of Assembly. He made reference to the subsisting order of interlocutory injunction put the suit number out there, restraining Martin Amaewhule and his co-travelers as lawmakers in Rivers State pending the determination of the substantive suit, which has not been appealed against till date. All right, so it's really getting interesting. But then again, if it were an order, this is just an academic question. If it were a pronouncement of courts saying that Martins, Amaewhule, and others are still lawmakers, would it have superseded the judgment by, or the interlocutory injunction by Justice Wali?
I am afraid the answer will be no, because the courts are courts of equal jurisdiction. They are courts of the same level who exercise the same power. At best, it would have been for the party in whose favor that judgment was given to draw the attention of the court in hearing the substantive suit. That is Justice Wali's, Honorable Justice Wali's court, to draw his attention in the substantive suit, hearing of the substantive suit, to the fact that a sister court has also had this matter, and this is what that court said, or the opinion that court said. But the opinion of that court will not have binding effect on Honorable Justice Wali's court, for the simple reason that it's not a superior court that has capacity to make a binding decision that he is bound to follow. So he will have a responsibility to look at the facts of the matter brought before him and reach a decision, as the matter is already in progress.
Okay, so we still have like 20 minutes on the clock. Let's do some calls now for the listeners so that they can call in and add their views on this very issue. What do you make of it? You listening right now? What do you make of the situation? What do you make of the judicial pronouncement by Justice Bassam? I'd like to hear from you. Let's get your thoughts. The numbers are the same, but for first timers, the numbers are 0817-923-0002, 0817-923-0003, 0817-923-0007. WhatsApp number 0809-0306-416. I am Kala Dakurubatibo. This is Hard Facts, and my guest is Professor Ritchard Wokocha. All right, let's get talking. Let's see who is on the line. Okay, I'm waiting for the calls to be picked, but let's listen to this now.
Good evening, Mr. Kalada. I am Amaewhule Fine Face, speaking from Ngutown, Andoni. The judgment of the court today does not give the Martins Amaewhule led faction of the River State House of Assembly, whose seat has been already declared vacant, any leverage to want to parade themselves as members of the River State House of Assembly, based on the fact that the Federal High Court has decided this matter, declaring their seats vacant and telling them that they are not members of the PDP. And then this other court called jurisdiction, and whatever they come up with will be null and void and ultra-virus to the extent of because this inconsistent, whatever they come up with is inconsistent with the rule guiding the ethics of the court proceedings, and I think that it doesn't stand the test of time. The judgment of today cannot stand the test of time, and so they have to, if they want to contest their validity as members of the River State House of Assembly, they will need to appeal to the appeal court and contest their validity. For now, they are not members of the River State House of Assembly until the judgment declaring their seats vacant, the interlocutory injunction declaring their seats vacant is vacated. Thank you very much. Amaewhule Fine Face from Ngotown.
Thank you very much. I've got Peter from Ozoba. Peter, welcome. What is on your mind? I'd like to hear from you.
Yeah, Canada. Good evening.
Yeah, greetings.
Prof, I have to thank God for you in this state of your profession, and you are doing it right well. These people who have ear to hear can hear clearly, because there's a lot of lawyers. All of them are passing through you. through in your trainings and all that, who will come and give us. I've just listened to different radio stations. I've listened both to paper here and there, and this kind of thing always engineer the followers. So I want to ask a question to you, Prof, on this issue, because I heard from Chidi Lloyd of Amaewhule chairman saying whatever that happened, anyhow it is, he will stay. It's not only him, about three of them. They will stay till they are still standing on this very declaration of the law they made. But I want to ask, what should the police? I know that the police they are watching, because within this week now, this is what we are only after. What will the police do in this case?
All right.
Because some of them say, I will obey this one. I will obey this other court. This one, I will obey this other court. What is, should you advise the police to do in times like this?
All right, Peter, we'll get an answer for your question, but let's listen to Princewill from Omagwa. Princewill, welcome on the show. What is on your mind, please?
Yeah, good evening, Canada.
Yeah, welcome.
Yeah, this is first-time caller.
All right, Princewill, welcome. It's good to have you.
Okay, I want to ask the lawyer in the House to confirm if the court ruled that Martins Amaewhule and his friends are still members of Rivers State House of Assembly.
But that's what we've been talking about. That's what we've been talking.
Yes. Does it mean that all the laws they have made and passed are still valid with regard to this local government extension of a local government chairman? I want the lawyer in the House to explain so that we'll be guided and know what is actually happening.
All right, then. All right, your question will be answered. Let's take Ida from Inkoro's call. Somehow he found his way to the studio today. Ida, welcome.
Clara, thank you very much.
All right.
Brother. I'm happy with you.
All right.
My brother, just like what your guest said, yes, guest has spoken my mind. Let me not talk further. Thank you very much. I remain on the Ida from Inkoro.
All right, thank you very much, Honorable Ida. This one says it's a big shame for spreading news and unconfirmed report. You all media houses have a long way to go. What's the unconfirmed report? There was the court case. They like we have said, the true certified copy of the judgment is not yet out. So what is the unconfirmed here? Anyways, thank you nonetheless for your thoughts there. I've got Jude from Omuma. Jude, welcome. What is on your mind?
Canada, just to remind everyone that besides other declarations made by the 7 lawmakers, they were received openly by APC at Polo Club.
Can that be used? Can that be used as evidence?
The chairman of APC openly received these 27 people as members of APC.
Okay.
So I just want everybody to note that in case we have forgotten. Thank you.
All right then. Thank you very much, Jude. I've got Ernest from Eleanor. Ernest, welcome. What is on your mind? Please tell me.
Yes, Canada. Good evening. How are you today?
I'm doing great. Welcome.
Happy New Week to you.
Same to you.
Canada, I don't know why we are making mockery of ourselves in this state.
Okay.
I don't think that even the judge that delivered that judgment today is even living in Rivers State here. That a speaker and his members rose from their sitting and declare their seat that they are no longer of a PDP and they are of All Progressive Congress. In this state too, they came up on their sitting arena and they are waving the APC flag. They even went as far as Wokocha, that claims to be Architect Chairman, hosted them for the defection at the GRA Polo Club. All these things have happened here.
All right.
And also the matter is even in Abuja, where they even had a suit using APC as their thing. And people are coming back and be talking about it's no longer they are a PDP member. They're making mockery of themselves.
All right then.
Yes, you better go and sit down and wait for 2027.
All right then.
If they really want to run an election.
All right then. Thank you very much.
And stop disturbing us in this state.
All right. Thank you very much, Ernest. Back to you, Prof. Prof, can you hear me now?
Yes, I can hear you.
So let's answer some of the few questions. One, someone is asking the laws made by Martin Amaewhule, given the fact that there is the interlocutory injunction, and you're saying that this pronouncement by Justice Bassam does not have any impact or effect on that interlocutory injunction, does it mean that the laws made are valid or not?
The laws made
by Martin Amaewhule, especially the local government extension.
After the defection.
After the defection.
You know, we have had that conversation before when some of those activities took place, and I told you that in the eyes of the law, not longer being members of the House of Assembly, they were not making any laws. Okay. They could only have been valid if they were still members of the House of Assembly. But because they have vacated their seats by proper interpretation of the Constitution, by the provisions of the Constitution, they were no longer lawmakers and could not have made any law. Okay. You and I cannot sit and make law for River State. So nobody could have made law for River State who is not or who has ceased to be a member of the River State House of Assembly.
All right. Some other person asked the question about, is it the APC chairman accepting them? Can that be evidence in court?
Sorry, can you take that question again?
The APC chairman in Rivers State accepted the 27 lawmakers into the APC. Someone is asking if that can be used as evidence in court.
Yes, that will also be evidence in furtherance of the fact that proper evidence has been presented showing their resignation, which they have presented publicly. And those are all follow-up actions that further confirm the fact of their having resigned from their party. Remember that you are on the seat in the name of a party. So when you leave that party, you have left the seat. That is the provision of the Constitution. When you leave that party for any other party that is not a part of your party, you have lost your seat.
Someone is asking, it says, good evening, Mr. Canada and Professor Wokocha. Please, it was also stated that the 27 members in their defense as to why the National Assembly shouldn't take over the Assembly deposed a suit that they defected because of the disputes of the National Secretaryship. If they are retracting or recanting such defection, does it mean the 27 lawmakers, having sworn to an affidavit, are liable to perjury, having lied about defection under oath? Text from Oyibo is asking.
Sorry, you are not quite, your voice is not quite strong this way, but if I get what you are asking, it's whether the fact that they have deposed to these facts, that they have stated these facts on oath in other suits before other courts, like the one in Abuja, whether it is also proof that they have actually defected.
Or the person is asking if they are recanting or retrieving that statement. Is it perjury?
Will affect that one.
If it is perjury and that's what lying under oath, that's what he's asking.
But as a matter of fact, if they stated on oath that they have defected and then they came up to issue statements that, we did not defect, it will not make that their statement a lie.
Okay.
What can only save you from that being a perjury is if you say, I later changed my mind after that oath. Then the subsequent action will not have been in breach of the law, because you are saying when you said it was true, but you changed your mind thereafter.
All right.
But if you are saying that what you stated on oath was never true, did not happen, then it means you lied on oath, and that becomes perjury. An offense for which you can be prosecuted and punished.
All right, then. We would have to say our goodbyes now, Prof. My time is fast spent, and I do have a commercial coming up. But thank you very much for your time, for educating.
Thank you very much.
People. All right, then do have yourself a fantastic evening, Prof.
Thanks for having me.
Okay, then.
Well done.
All right. For those of you listening, do stay tuned. We would have this conversation again, the open season. I do have a commercial right now, so I can't do too many messages. This one says, I think the brouhaha is getting shameful and irritating. Justice Omotosho's judgment remains the most valid decision on this matter, in my opinion. However, I want to find out from Professor Ritchard on Omotosho's judgment. Is it a matter of nullity? Okay, I do have a commercial now, so I can't read all of that message, but thank you very much.